I watched a stranger walk into my house at 11:47 a.m. on a Tuesday. Not a burglar, not a neighbor borrowing sugar. A woman in a blazer carrying a clipboard and a measuring tape, followed by a man with a camera, both of them entering through my front door using a key I never gave them. I watched it happen from my desk at work 22 miles away on a security app that sends motion alerts to my phone. And I sat there in my office chair with my coffee going cold and my heart going fast as they spent 38 minutes inside my home. They measured my kitchen countertops. They photographed my bedroom. They opened my closets. They looked inside my medicine cabinet, and the man with the camera took a picture of the prescription bottles on the second shelf. They walked through every room of a home I owned, a home I'd locked that morning, a home where my 12-year-old daughter's bedroom door has a poster of BTS on it and a diary on the nightstand that she writes in every night before bed. They were in her room for 6 minutes. I know because the hallway camera has a timestamp and I've watched the footage more times than is probably healthy. They were sent by the Crestwood Manor Homeowners Association. They had a key because the hose management company keeps copies of every homeowner's key in a lockbox at their office. A policy buried in paragraph 47 of a document I signed at closing without reading. Because nobody reads every paragraph of every document when they're rebuying their first house and the mortgage. Broker is tapping his pen, and the seller is waiting, and your daughter is in the car asking if her new bedroom is the one with the window seat. Paragraph 47 authorized the association and its agents to access the interior of any unit for the purpose of inspection, maintenance, or enforcement of community standards upon reasonable notice to the homeowner. Reasonable notice. I received no notice, no call, no email, no letter, no knock on the door from a neighbor saying, "Heads up, someone's coming into your house today." They just walked in, and the things they found inside became the basis for $11,000 in fines that nearly cost me my home. But the footage of them entering became something else entirely. Criminal evidence. And the difference between those two outcomes is why I'm telling you this story. My name is Jordan Avery, 36 years old, single father. I work as a systems analyst at a healthcare company in suburban Minneapolis, which is a fancy way of saying I stare at databases and fix things that break in ways nobody predicted. I bought my townhouse in Crestwood Manor in 2021 because it was what I could afford after my divorce, which left me with primary custody of my daughter Chloe, a car payment, and the specific exhaustion of someone who spent 2 years arguing about everything and had nothing left to argue with. Crestwood Manor is a townhouse community in Maple Grove, Minnesota. 144 units built in 2006. Arranged in clusters of 4 and 6 with shared walls and shared parking and shared frustrations. The townhouses were fine. Not beautiful, not ugly. The kind of housing that exists to be adequate, with vinyl siding in 3 approved colors and garage doors that all look the same in a uniformity that's either comforting or suffocating depending on your tolerance for beige. The HOA was managed by a company called North Star Community Management, one of those firms that handles dozens of associations simultaneously and treats each one with the attention span of a goldfish in a bowl full of other goldfish. The on-site board had 5 homeowner volunteers. The president was a man named Dale Hoffman, 59, retired building inspector for Hennepin County, who brought to HOA governance the same energy he'd presumably brought to inspecting other people's properties for code violations. which is to say meticulous, intrusive, and utterly convinced that every wall hides a problem. Dale and I had no history. I'd been in the community for 2 years, with 0 violations. I mowed when the schedule said mow. I shoveled when the schedule said shovel. I kept my garage door closed and my trash cans hidden, and my opinions about the HOA's mulch color selections to myself. I was invisible, which in an HOA community is the highest compliment. The inspection that I didn't know about happened because of a water stain. The unit next to mine, owned by a woman named Patricia Cole, had developed a brown stain on her living room ceiling. Patricia reported it to Northstar, who sent a maintenance tech to investigate. The tech determined that the stain might be caused by a leak originating in my unit, specifically from a bathroom on the shared wall. Northstar scheduled an inspection of my unit to locate the potential leak source. That's the part that almost makes it reasonable, almost. Because water leaks in shared wall townhouses are serious. They cause mold, structural damage, insurance, nightmares. If my bathroom was leaking into Patricia's ceiling, it needed to be found and fixed. I would have agreed to an inspection. I would have taken a morning off work, unlocked the door, and stood there while they looked. I would have been cooperative because I am a cooperative person, and because a leak is a leak, and pretending it doesn't exist doesn't stop the water. But they didn't ask me. They didn't call my phone number, which was on file with Northstar. They didn't email my address, which was on file with Northstar. They didn't send a letter, which the CC&Rs required. They used paragraph 47 like a skeleton key and walked into my home on a Tuesday morning while I was at work and my daughter was at school, and the only witness was a $200 security camera that I'd installed after a package theft 6 months earlier. I found out because of the motion alert. My phone buzzed at 11:47 a.m. I opened the app, expecting to see a delivery driver. Instead, I saw a woman I didn't recognize, unlocking my front door with a key and entering my house, followed by a man carrying a professional camera. My first thought was burglary. My second thought was that burglars don't usually wear blazers and lanyards. My third thought was to call 911, which I did from my desk at work, while simultaneously pulling up the live camera feed on my laptop. The 911 dispatcher asked if the intruders were still inside. They were. I could see them on camera, the woman writing on her clipboard in my living room while the man photographed the baseboards. The dispatcher sent a patrol unit. I told my supervisor I had an emergency and drove home at speeds that would have generated their own set of legal issues if anyone had been paying attention. I arrived at the same time as the police. 2 officers, a man named Gustafson and a woman named Pham, met me in the driveway. The woman in the blazer and the man with the camera were standing on my front steps, looking confused and slightly offended. The way people look when they believe they've done nothing wrong and couldn't understand why anyone would suggest otherwise. The woman identified herself as Sandra Kiefer, a compliance inspector for Northstar Community Management. The man was Ray Donovan, a contractor Northstar used for documentation and assessment. Sandra explained to Officer Gustafson that she was conducting an authorized inspection of the unit pursuant to the HOA's governing documents. "Does the homeowner know you're here?" Gustafson asked. The association authorized the inspection. The governing documents grant access. That's not what I asked. "Does the homeowner know you're here?" Sandra looked at me as if noticing me for the first time. She was about 50, professional, with the practiced composure of someone who'd been challenged before and won. I'm not required to notify the homeowner individually. The CC&Rs provide blanket authorization. No, they don't, I said, and I was surprised by how steady my voice was because inside I was shaking. Section 47 requires reasonable notice. I received no notice of any kind. Sandra opened her clipboard. The inspection was scheduled through our office. Notice was sent to the property address. She meant they mailed a letter to my house, the house I wasn't in because I was at work. The house they entered before the letter could have possibly arrived even if they'd sent it, which I would later discover they hadn't. They hadn't sent anything. The notice was listed as pending in Northstar's internal system, which meant someone had created a notice document but never actually mailed or emailed it. Officer Gustafson looked at me. Do you want them on your property? No. Then you need to leave, he told Sandra. The homeowner hasn't authorized your entry. Regardless of what your documents say, entering someone's home without their knowledge or consent is potentially criminal trespass under Minnesota law. Sandra's composure cracked slightly. We were inspecting for water damage. This is routine. There's nothing routine about being inside someone's home without their permission. Gustafson handed me his card. You can file a formal report at the station. I'd recommend preserving any security footage you have. Sandra and Ray left. I went inside and walked through my house the way you do when someone else's been in it without your permission. Touching door frames, checking drawers, looking for anything moved or missing. Nothing was stolen, but things had been disturbed. My bathroom cabinet was open. The shower curtain was pulled back. In Chloe's room, the closet door was ajar. It had been closed when I left. The camera in the hallway confirmed what happened. Sandra had opened Chloe's closet, looked inside for approximately 15 seconds, then closed it incompletely. I sat on Chloe's bed and felt a kind of violation that I hadn't expected. My house wasn't ransacked, nothing was broken. But the boundary that makes a home, the boundary between inside and outside, between private and public, between mine and theirs, had been crossed by people I didn't know for reasons I hadn't approved. They'd been in my daughter's room. They'd photographed my medications. They'd measured my kitchen like they were appraising it for sale. That night I told Chloe what happened. She was quiet for a long time, which for a 12-year-old who normally narrates her entire existence is significant. Then she asked, "Did they read my diary?" "I don't know, baby." She went to her room and closed the door. I heard her lock it, something she'd never done before. The next morning, I filed a police report. Officer Pham took my statement in a USB drive with the security footage. She watched the key entry on her desk monitor and I saw her expression change. "They had a key to your house?" "The management company keeps copies. It's in the C&Rs. Pham wrote something down. "That's unusual for a townhouse association. Condos sometimes, because the association typically owns the building envelope. But townhouses? You usually own the structure. Let me check with the county attorney." 2 days later, Pham called me. The county attorney's office has reviewed the footage. They're referring it to the criminal division for potential charges of unauthorized entry under Minnesota Statute 609.605. Criminal charges against Sandra. against Sandra Kiefer individually and North Star Community Management as a corporate entity. The statute covers entering a dwelling without claim of right. The county attorney's position is that paragraph 47 of your CC and Rs does not constitute claim of right because the notice requirement was not satisfied. Without proper notice, the entry was unauthorized, regardless of the blanket access provision. I called a civil attorney that afternoon. His name was Eric Lindquist, a property lawyer in Plymouth who specialized in HOA disputes and had the weary competence of someone who spent 20 years watching community associations make avoidable mistakes. Eric reviewed the footage, the CC&Rs, North Star's internal records, which we obtained through a data request under Minnesota's homeowner access statute, and the police report. Then he laid out the landscape. You have 3 tracks. Criminal, that's the county attorney's case. You're a witness, not a party. You don't control it. Civil against North Star, for unauthorized entry, invasion of privacy, and negligent supervision of their inspector. And civil against the HOA board if they authorized the inspection without ensuring proper notice. He paused. But there's a complication. There's always a complication. North Star's inspection found something. Eric opened a folder. 2 days after the unauthorized entry, North Star sent you a violation report. Based on their inspection, they documented 11 violations. He read them. Unapproved paint color in the master bedroom. Modification to bathroom fixtures without architectural approval. Installation of a security camera on the exterior without board approval. Storage of unapproved items in the garage, which meant my daughter's bicycle and my toolbox. Damage to interior drywall, which was the water stain they'd been looking for. Pet without registration, that was Chloe's hamster. Window treatments not conforming to exterior appearance standards, because my bedroom blinds were gray instead of white. 6 more items of similar absurdity, each carrying a fine between $200 and $1,500. Total fines assessed, $11,200. They broke into my house and then fined me for what they found inside. Essentially, yes. And here's the legal issue. The evidence they gathered during the unauthorized entry is the sole basis for the fines. If this were a criminal case, the evidence would be suppressed as fruit of the poisonous tree. But HOA enforcement isn't criminal court. There's no Fourth Amendment protection against private entities. The exclusionary rule doesn't apply. So they can use illegally obtained evidence to fine me. In theory, but we go on to argue that the fines are unenforceable because they based on an inspection that violated their own governing documents. If the inspection was invalid, the findings are invalid. That's a contract law argument, not a constitutional one, but it works. Eric filed 2 motions simultaneously. The first was a challenge to all 11 fines, arguing that evidence obtained during an unauthorized entry that violated the CC&R's own notice requirement could not form the basis for enforcement actions. The second was a civil lawsuit against North Star for unauthorized entry, invasion of privacy, and intentional infliction of emotional distress, with a specific count for the intrusion into Chloe's room. The Ox response came through their attorney, a woman named Karen Albrecht, from a firm that represented a dozen North Star managed communities. Her argument was predictable and almost persuasive. The inspection was conducted in good faith to investigate a water damage complaint from an adjacent homeowner. The C, C, and Rs authorize interior access. The notice requirement is administrative, not jurisdictional, meaning failure to provide notice makes the entry improper but not illegal. The fines are based on legitimate violations that exist regardless of how they were discovered. Eric destroyed the argument in 3 sentences during the preliminary hearing. If the notice requirement is merely administrative, then it's meaningless. If it's meaningless, then the CC and Rs contain a provision that authorizes unlimited, unannounced entry into any homeowner's residence at any time for any reason. That's not a community association. That's a police state. The hearing officer, a retired judge named Margaret Sue who handled HOA arbitrations, raised her eyebrows. She turned to Karen Albrecht. Is that really your position, counselor? That the association can enter any home at any time without notice? Karen backtracked. We're not arguing unlimited access. We're re-arguing that substantial compliance with the notice provision is sufficient, and that the good faith purpose of the inspection mitigates the procedural deficiency. What notice was provided? Karen checked her file. A notice was generated in Northstar's system on October 14th. Was it sent? It was in the outgoing queue. Was it sent? Karen paused. It had not been physically mailed at the time of the inspection, so no notice was provided. Not technically, no. Margaret Sue ruled from the bench. All 11 fines were vacated. The inspection was unauthorized under the association's own governing documents. Evidence obtained through an unauthorized inspection cannot form the basis for enforcement actions. The HOA was ordered to pay my arbitration costs of $3,200. It was a clean win on the fines. But it was only the first track. The civil case against Northstar moved forward through discovery. Eric subpoenaed Northstar's records for every inspection they'd conducted across all communities they managed in the previous 5 years. What came back was disturbing. Northstar had conducted over 300 interior inspections across 22 communities. Of those, 112 had no documentation of homeowner notification. In 47 cases, the homeowner was confirmed to have been absent during the inspection. In 9 cases, homeowners had filed complaints about unauthorized entry. Northstar had settled 4 of those complaints quietly with payments ranging from $2,000 to $8,000. This wasn't a one-time mistake, it was a pattern. Northstar treated homeowner notification as optional because skipping it was faster and nobody had made them pay enough to change the behavior. Eric amended the complaint to include a pattern and practice claim. He also contacted the attorneys who'd handled the 4 prior settlements. 2 of them joined as co-counsel, adding their clients' claims to a consolidated action. Northstar's insurance company started paying attention. Their adjuster called Eric in January 2024 with a settlement offer. $50,000. Confidential, full release of all claims. Eric called me. It's a real number. Not life-changing, but real. You'd net about 32 after fees. The alternative is trial, which is 12 to 18 months away, and involves Chloe potentially testifying about her room being entered. I hadn't thought about Chloe testifying. The idea of my daughter sitting in a courtroom describing how she started locking her bedroom door because strangers had been inside it made me physically ill. But I thought about those 112 uninvited inspections. 47 homeowners who came home to houses that had been entered without their knowledge. 9 who complained. Only 4 who'd gotten anything. and hundreds more who never knew it happened because they didn't have cameras. I want $75,000. A public admission that the entry was unauthorized. Mandatory notification protocols implemented across all North Star communities, and the termination of Sandra Kiefer. Eric relayed the demand. North Star countered at 60. I held at 75. They met me at 70 with everything else I'd asked for except Sandra's termination. Their HR policies prevented them from terminating an employee as a condition of a legal settlement. She was, however, reassigned to a position with no homeowner contact and required to complete training on privacy law and homeowner rights. I accepted $70,000. After Eric's fees, I netted $45,000. I put $20,000 into a college fund for Chloe and used the rest to pay down the mortgage. Not life-changing money, but real money that came from a real violation that was really acknowledged. The criminal case resolved separately. The county attorney charged Sandra Kiefer with 1 count of unauthorized entry, a misdemeanor. She pleaded no contest in April 2024 and received a sentence of community service and a fine. North Star was charged as a corporate entity and paid a $10,000 fine. Neither amount was significant enough to make headlines. But the charges created a record. A criminal record for entering someone's home without permission. A precedent, small but real, that. Paragraph 47 of a CC&R document is not a master key to someone's life. Dale Hoffman resigned as HOA president 2 months after the arbitration ruling. Not because he was forced to, but because the consolidated lawsuit had revealed that he depersonally requested 3 unauthorized inspections in the previous year. None involving water damage. All involving homeowners he'd had disputes with. The board asked for his resignation quietly. He gave it quietly. The new president is a woman named Anita Desai, a corporate compliance officer who ironically spent her professional life ensuring that companies followed proper procedures. Her first act was changing the locks on the North Star key lock box and implementing a policy requiring written homeowner consent with 72 hours advance notice for any interior inspection. I changed my locks the day after the initial incident, installed 3 more cameras, got a video doorbell. My house now has more surveillance than a convenience store, which is not how I wanted to live but is how I live now. Chloe still locks her bedroom door every night. I asked her once if she wanted to stop. She said it makes her feel safe, a 12-year-old girl who locks her door because adults she'd never met were in her room looking in her closet while she was at school. That's the cost. That doesn't show up in any settlement. I think about Sandra Kiefer sometimes. She wasn't a burglar. She was doing a job she'd been trained to do by a company that treated homeowner privacy as an obstacle to efficiency. She walked into my house because nobody told her she couldn't, because the system she worked in had made unauthorized entry so routine that it didn't register as wrong. That doesn't excuse it, but it explains it. And the difference between an excuse and an explanation is the difference between letting someone off the hook and understanding how the hook got set in the first place. North Star still manages Crestwood Manor. The new board chose not to terminate the contract. Because switching management companies is expensive and disruptive, and the devil you know is sometimes preferable to the devil you do UNT. Especially when the devil you know just got charged with a misdemeanor and is now very motivated to follow the rules. Chloe asked me recently if the HOA could come inside again. I told her no. That we changed the locks, that the law protects us. That nobody enters our home without our permission. She nodded and said, "Okay." Then she locked her door. Some locks are physical. Some are the kind a 12-year-old puts on her sense of safety after she learns that home doesn't automatically mean safe. No settlement fixes that. No policy amendment undoes it. You just live with it and hope that time does what money can't. If your HOA or management company has entered your home without proper notice and explicit consent, you need to know 3 things. First, most states require specific notice for interior inspections, even when CC&Rs contain access provisions. Read your governing documents and know what notice they require. Second, install security cameras, interior and exterior. The footage saved my case and it will save yours. Third, file a police report immediately. Criminal trespass statutes apply to HOA agents the same way they apply to anyone else. A clipboard and a lanyard are not a warrant. Drop your story in the comments if your HOA has entered your home without permission, searched your property, or used their access keys for anything other than a genuine emergency. I want to hear it. Every story documented is another reason to change the laws that let this happen. Subscribe if you believe your home is your home, not your HOA's inspection site. Next week, an HOA installed cameras pointing into a homeowner's bedroom window. The privacy lawsuit exposed their entire surveillance network. You'll want to see that. Keep your receipts. Lock your doors. Sue the HOA.